Mr. Speaker, sir, I'm always delighted to speak immediately after the Prime Minister, because most likely he would have covered everything that I want to say. Mr. Speaker, sir, I'm always delighted to speak immediately after the Prime Minister, because most likely he would have covered everything that I want to say and in a more eloquent way as well. Sir, I first raised the issue of a review of the Penal Code in the budget debate in 2002. Now, while it has taken some time for the present amendment bill to be tabled, I'm delighted that we have finally come to a stage where the primary legislation on criminal law is on the brink of being revised. Sir, the amendment bill has done much to update our penal laws, and I would like to commend the various agencies that were involved in this exercise, including the Ministry of Home Affairs, the Ministry of Law, the Attorney General's Chambers, and the organizations and individuals who have given their views on the amendments. It has indeed been an arduous task, and much thought and effort must have been expended in putting this bill together. Now, much heat and debate has been generated on a few of the proposed amendments, especially on Section 377A. But the amendments are significantly more than just a few of the controversial sections. Now, bold initiatives such as the proposed criminalization of sex tourism must be commended for the very forward-thinking and reflective of the issues affecting society in present day. Now, likewise, enhanced penalties for racially or religiously aggravated offences are, in my view, extremely appropriate for this day and age, and I'm sure will have no detractors. Now, sir, the amendment bill seeks to make our penal laws more gender-neutral. The proposed repeal of Section 498, under which only men can be charged for an offence that both men and women are quite capable of committing, is a good example of how we have made progress in this front. Now, sir, some years ago, I had asked for a review of this section, as it did not seem right that only a man can be imprisoned for up to 2 years and be fined for enticing a married woman away from her husband. However, a woman who entices a married man away from his wife, which I think is more often the case, committed no crime. Now, perhaps she would have earned a bad reputation, but she was not guilty of any offence under the Penal Code. So other steps in the same direction include the substitution of spouse for wife and child for son in various provisions of the Code. Now, what puzzles me is why this exercise of gender neutralization was not taken further, with the Code applying equally to women as it does to men, to the extent that it is physiologically appropriate for it to do so. So the retention of Sections 366, 377A, 493 and 509 as is a blemish on what would have been otherwise a very successful exercise in having a code that treats women and men equally. For example, Section 493 makes it an offence for every man who by deceit causes any woman who is not legally married to him to believe that she is married to him and to cohabit and to have sexual intercourse with him. An offender under this section is liable to imprisonment of up to 10 years and will also be subject to a fine. However, a woman who commits the same act in respect to any man will not have committed any offence. So Section 493 as it stands implies that only women can be duped by men into believing that they are married to them, while men are never fooled. So it is somewhat insulting to women and perhaps gives men a little too much credit. So Section 509 makes it an offence punishable by imprisonment of up to 1 year and fine to intentionally insult the modesty of a woman by uttering any word, making any sound, showing any gesture, or exhibiting any object. However, it is not an offence if the victim is a man. It implies that men are less modest and can never be insulted by words, sounds, gestures, or objects. So in the same vein, while Chapter 7 of offences relating to the armed forces may, by virtue of the interpretation of the word servicemen in the SAF Act, be construed to apply to women as well as to men serving in the armed forces, the exception in the Penal Code Section 136 is currently not gender equal. Now, Section 136 refers to punishment of up to 2 years imprisonment or a fine for harbouring a deserter. Now, this provision does not apply to a wife who gives harbour to a deserter husband. On the other hand, a husband who gives harbour to his wife, who is an SAF deserter, is subject to punishment under the law. Now, perhaps the exception should be made applicable to both husbands and wives, rather than limited only to wives. So it is not completely outrageous to conceive of the offences under the sections that I have mentioned being committed by both men and women. And I would have thought that it would have been an opportune time to amend the language of these sections in the same way that the other previously gender-biased provisions were reviewed. So I would now like to address what appears to be Orwellian thought crimes in the Penal Code. So sections 121A of the Code stipulates the death penalty and a fine for anyone who imagines harm or the death or the imprisonment of the President. Section 121B provides for the imprisonment for life and a fine for whoever who imagines the deprivation or the disposition of the President from the sovereignty of Singapore or the overthrow of the government by criminal force. Now, sir, this may be part of our colonial legacy and can, I believe, trace its roots to the United Kingdom's Treason Act, which I was told was passed in 1351, more than 6.5 centuries ago. So the use of the word imagine in those sections is unfortunate, as the modern meaning of the word detracts from the meaning it used to have. So the shorter Oxford English Dictionary, in referring to precisely the type of archaic language set out in sections 121A and 121B, says that imagine in this context means to devise, to plot, or to plan. It is of course right that anyone who plots, plans, or actually takes action against the person or the office of the President ought to be punished. But merely imagining any of these, now should this really be on our books? So the Amendment Bill also addresses the issue of marital rape. While I note that slight headway has been made in diluting the blanket marital rape exemption, I share the disappointment with the many other members who spoke before me that we have not chosen to adopt the same enlightened position that countries such as the United Kingdom and even conservative India have taken in criminalizing marital rape without exemption. At a supranational level, the United Nations Declaration on the Elimination of Violence Against Women specifically refers to marital rape as a form of violence against women. It therefore baffles me that the Amendment Bill seeks to disapply the marital rape exemption only when certain conditions apply. Now, we have moved beyond the outdated thinking that a woman gives her husband her irrevocable consent to engage in intercourse with her at any time. And I do not recall ever seeing in any marriage vow where the bride explicitly gives such a consent. So, intercourse against a woman's consent is rape, whatever the context. Now, let us get this straight. No ifs, no buts. It is no less deplorable because the parties are married to each other and are not subject to any matrimonial or judicial proceedings. My opinion is that the inclusion of the provisions of the proposed sections 375(4) and 376(5) will do us a great disservice, and I'm really hard-pressed to understand how we can justify Neanderthal-like behavior in this day and age. So another provision that has generated much controversy is section 377A. Much has already been said on this section, and I'm not sure if I can add anything that has not already been said. And I shudder at the thought already of adding more because of the passion that's been shown in this House. But I think I would be remiss as a legislator if I merely hid behind the views of the Conservative majority and maintain the status quo, which of course would be the least inconvenient thing to do if you're not gay. So I'm not convinced that there would be drastic consequences in our society if we do not repeal 377A, as the section has been in the Penal Code since the Code was adopted in 1871, I think. Neither am I convinced that we will all rapidly slip down the slippery road if we were to repeal 377A, as suggested by some members. The slippery road argument has less of an impact on me these days, as I've heard that sort of argument used many times before. Now, some years ago, a senior politician, who shall remain unnamed, argued his case as eloquently and as convincingly as some of our NMPs did yesterday in retaining an archaic regulation. The removal of such regulation, it was said, would have led to conflicts, fights, and murders if it were to be abolished. Well, we have abolished that archaic regulation and permitted bar-top dancing for some years already, and the world has not come to an end yet. So, if the experts and MM and PM are indeed correct, and some of our MPs wrong, that some of us are indeed born with different sexual orientations, then it would be quite wrong of us to criminalize and to persecute those that are born different from us, regardless of how conservative a society we claim to be, especially if their actions do not cause harm to third parties. So we also claim to be a secular and inclusive society. We should therefore respect the private space of those who are born different from us as much as we expect them to respect our common space. Therefore, if we do retain Section 377A, which is most likely the case, as the Prime Minister has said so already, then we should exclude criminalizing acts done in private between consenting adults of full capacity. Enforcing Section 377A for acts done in private would be onerous if we do not have the equivalent of religious vigilantes that some of our neighboring countries have to spy on what takes place in the bedrooms and hotel rooms. And is it really the business of government to regulate acts between consenting adults born with different sexual orientations in the privacy of their bedrooms? So, if we had intended the retention of 377A in the Penal Code as an expression of our conservative values, rather than to be proactively enforced, as some have suggested, then I think we have come out short, even in this respect. The section criminalizes act of gross indecency in public and in private only if it is engaged between men. Now, surely the Minister must acknowledge that women are as capable as men of committing such acts. Is Section 377A, therefore, as it stands, a correct statement of our values and principles? Or are there no lesbians in Singapore? So it would not be simply realistic to expect the majority of Singaporeans to ever reach a position of being pro-homosexuality, or where they will actively seek to repeal 377A as a matter of priority. Now, even if heterosexual Singaporeans are apathetic towards homosexuality, it would be much easier just to maintain the status quo than to take steps to modify or even expunge 377A from the Penal Code. Now, having said all this, Section 377A is useful in one regard, as it is currently an offence for a man to procure or attempt to procure the commission of an act of gross indecency with another man. Now, this gives some protection to men who are subjected to unwanted sexual advances of other men, and should continue to be an offence whether these advances are made in public or in private. The section should, however, be extended to protect women who face the same sort of harassment from other women. Now, this is a rare case of the Penal Code providing more protection to men than it does to women. It is unfair and may even be unconstitutional that women do not, in this respect, currently have the same sort of protection that men have under the law. So ultimately, my question, like that asked by other members, is if we did not have Section 377A in the Penal Code today, would we think it fit and proper to enact a provision in exactly the same terms? Would we not be seen as being narrow-minded, perhaps even bigoted in our philosophy towards people who are born different and engage in practices not approved by the majority, even if no harm is done to others? If we would not, then I think we should show leadership and convince the majority to do what is fair, just, and representative of the age in which we live, and that it does not make sense to have a law we do not intend to proactively enforce, and that intimate relations between consenting adults in the privacy of one's bedroom is not the business of the government. So finally, sir, I support the many changes made in the Penal Code, not only to expunge archaic laws and terms. I was delighted to hear the Senior Minister say that there's no more terms of pull-up, ice house, and horse carriages in the Penal Code, but also to bring the existing laws up to date with our present-day situation. Now, although in several areas I think we could have done better, now overall it was quite a commendable effort, and I hope the Minister would continue to refine the provisions further in the very near future and to seriously consider expunging laws that we have no intention to enforce.
Lim Chong.